If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring ownership of your assets to a beneficiary, or giving your assets away. How can you avoid probate? If you plan your estate carefully and properly, you can avoid probate altogether. One way to avoid probate is to create a trust. A trust is an arrangement in which property is held by one person, the trustee, for the benefit of another person, the beneficiary. Trusts can be used to avoid probate because the property in the trust does not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death (TOD) beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like, share, and subscribe to our channel for more insightful content.
In our last video, we discussed the Medicaid look-back period and potential penalties. Today, we're going to explore important asset protection strategies for Medicaid planning. These strategies can help preserve your assets for your spouse and heirs while ensuring you remain eligible for Medicaid. Why is asset protection so important? When planning for long-term care, it's crucial to balance protecting your assets with meeting Medicaid eligibility requirements. Preserving your assets ensures your spouse and heirs are not left financially vulnerable. Let's dive into some common asset protection strategies. First, irrevocable trusts. Placing assets into an irrevocable trust means you no longer own them, so they aren't counted towards Medicaid's asset limits. This can be a powerful way to shelter your assets. However, remember that once the assets are in an irrevocable trust, you can't access them or change the trust terms. It's essential to work with an experienced attorney to set up the trust correctly. Second, Medicaid-compliant annuities. These annuities convert a lump sum of money into a stream of income. Medicaid-compliant annuities meet specific requirements to ensure they aren't counted as assets. They must be irrevocable, non-assignable, and pay out within your life expectancy. This strategy can be beneficial, but it's important to understand the terms and potential impact on your income. Third, life estates. Creating a life estate means transferring ownership of your home to someone else while retaining the right to live there for the rest of your life. The value of the home is no longer considered an asset for Medicaid purposes. However, if the home is sold during your lifetime, you may receive a portion of the proceeds, which could affect your Medicaid eligibility. This approach requires careful planning and understanding of your state's rules. Aside from these, there are other legal tools you might consider. Long-term care insurance can help cover the cost of nursing home care, reducing the need to spend down your assets. Family caregiver agreements allow you to compensate family members who provide care, which can also help manage your assets within Medicaid's guidelines. It's crucial to consult with professionals when planning your asset protection strategy. An experienced attorney who has dealt with elder law and Medicaid planning can help tailor these strategies to your specific circumstances. They can provide guidance on the best approach for preserving your assets while ensuring Medicaid eligibility. In summary, protecting your assets is a vital part of Medicaid planning. By using tools like irrevocable trusts, Medicaid-compliant annuities, and life estates, you can preserve your wealth for your loved ones. Consulting with a knowledgeable attorney will ensure your plan complies with Medicaid regulations and meets your personal needs. Thank you for watching. If you have more questions or need personalized advice on asset protection strategies for Medicaid planning, consult with a qualified attorney to explore your options. Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The Franchise Agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
When you pass away, your debts do not expire with you. Most debt still needs to be paid off, if possible. although who is responsible for paying the debt depends on the type of debt, and some assets are protected from being used to satisfy a debt. Outstanding debt may include mortgages, credit card bills, car loans, personal loans, or condominium fees. Usually, your estate is responsible for paying any debts you leave behind. If the estate does not have enough money, the debts will go unpaid. In general, debt collectors may not try to collect payment from your relatives and heirs. However, there are some exceptions. Co-signers and guarantors of a particular debt are responsible for that debt, and someone who held property jointly with you would be responsible for any debts on the joint property. In addition, spouses in community property states may be responsible for some debt. Creditors are paid from the part of your estate that passes through probate, which means any property that passes through a will. The person who is appointed personal representative or executor of your estate is responsible for making sure the creditors are paid. The personal representative uses estate assets to pay off the debts before any money passes to heirs. If you have significant debts, it is possible that your entire estate will be used to pay creditors. Creditors cannot be paid from any assets that pass directly to a beneficiary. For example, a jointly held bank account would pass directly to the joint owner, and the funds in that account could not be used to pay creditors. Similarly, life insurance policies pass directly to the beneficiaries, so creditors do not have access to those funds. Whether or not a creditor can access funds in a trust depends on state law as well as what kind of trust it is. Contact Heritage Law Office to make sure your assets are protected.
Whether you're trying to avoid probate, protect your assets, or plan for your family's future, understanding trusts could save you thousands of dollars and months of headaches. But here's the thing most people get wrong about trusts. There are actually 3 simple steps to transfer your house into a trust, and we're going to break down each one so clearly that you'll wonder why you ever thought it was complicated. Plus, we'll reveal the one mistake that could completely invalidate your trust that many people make. First, you need to create the trust document itself. This isn't just filling out some random form online. The trust document establishes who controls the property, who benefits from it, and what happens when you're no longer around. You'll need to decide between a revocable living trust, which you can change anytime, or an irrevocable trust, which offers stronger asset protection but can't be modified easily. Next comes the actual property transfer. This means preparing a new deed that transfers ownership from your name to the trust's name. The deed must be properly notarized and recorded with your local county recorder's office. Without this step, your house never actually enters the trust, no matter what paperwork you've signed. Finally, you'll need to update all related documents and accounts. This includes homeowners' insurance policies, property tax records, and any existing mortgages. Many people forget this crucial step and end up with coverage gaps or compliance issues. The bottom line is this: transferring your house to a trust isn't rocket science, but it does require attention to detail and proper execution to protect what matters most.
The same way that an LLC or a corporation is a different entity from its shareholders. A trust is a different legal entity from the trust creator. Trusts are capable of acting independently, owning assets independently, filing lawsuits, and being sued themselves. It is because of these functions that we need to be cautious when it comes to transferring qualified assets, such as an IRA or 401k, to a revocable trust. The transfer of an IRA or 401k to a trust is similar to transferring it to a different owner, such as a different person, a different corporation, a different entity, and in doing so, the IRS considers this a taxable distribution. Similar to qualified assets, when a health savings account and medical savings account are transferred to a trust, they may be subject to taxes. Additionally, transferring a vehicle to a trust may result in the need to pay title transfer fees and additional taxes for issuing the new title. This list is not exhaustive. Other than the above-mentioned items, a revocable living trust may be a good option for the majority of your assets. This means your bank account, your house, your post-tax investment account, etc., should likely be transferred to a trust. You should pay special attention to retitling your assets to a trust to avoid unwanted taxes or other consequences. Contact one of our attorneys to make sure your assets are properly protected.
To date, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1, financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2, peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3, cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options. The role of life insurance in succession planning. Welcome back to our series on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Life insurance can play a critical role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of your business for the future. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you.
Think you're too young to need a will? If you're over 18 and have anything, like a bank account, car, or kids, it matters. Without a will, the law decides who gets what. And if you have children, the courts may choose who raises them. It might not be the person you'd want. Even a simple will gives you control over your assets and your wishes. It protects the people you care about, no matter your age or income. Waiting until you're older? That's one decision your family might pay for.
Welcome back to our series on estate planning for business owners. In our last video, we introduced the importance of estate planning for your business. Today, we're going to focus on a critical component of that process, business succession planning. So, what exactly is business succession planning? Simply put, it's the process of preparing for the transfer of your business ownership and management to someone else when you retire, become incapacitated, or pass away. This plan ensures that your business can continue to operate smoothly and successfully, regardless of what the future holds. Business succession planning involves several key steps. Let's break them down. First, identify potential successors. This could be a family member, a key employee, a business partner, or even an outside buyer. The right choice depends on your business structure, your family situation, and your personal wishes. It's important to evaluate the skills, experience, and readiness of potential successors to ensure they can effectively take over the business. Second, develop a formal succession plan. This plan should outline the process for transferring ownership and management of the business. It includes legal documents such as buy-sell agreements that detail how the transfer will occur and under what conditions. The plan should also address the financial aspects of the transition, such as business valuation, funding mechanisms, and tax considerations. Third, prepare your successor. This involves training and mentoring the chosen individual to ensure they have the necessary knowledge and skills to lead the business. Gradually increasing their responsibilities can help them gain confidence and experience. This step is crucial to maintaining continuity and preserving the business's value. Fourth, communicate your plan. It's important to share your succession plan with key stakeholders, including family members, employees, business partners, and advisors. Open communication helps prevent misunderstandings and conflicts, ensuring everyone is on the same page regarding the future of the business. Why is business succession planning so important? Without a solid plan in place, the transition of your business can be chaotic and disruptive. It can lead to conflicts among family members or business partners, loss of key employees, and a decline in business value. A well-thought-out succession plan, on the other hand, Provide stability and continuity, protecting your business's legacy and ensuring its ongoing success. Succession planning also has significant financial implications. Proper planning can help minimize taxes and other costs associated with the transfer of ownership. It can also ensure that your retirement is financially secure and that your heirs receive their fair share of the business's value. In summary, business succession planning is about preparing for the future and ensuring your business can thrive without you. It involves identifying potential successors, developing a formal plan, preparing your successor, and communicating the plan to all relevant parties. Thank you for watching. In our next video, we'll dive into the steps for creating a robust business succession plan. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
You may ask, why should I avoid probate? The answer is simple: time and money. The probate process can be cumbersome and take significant time and money. However, the probate process can be avoided. Trusts, when properly set up and funded, can avoid probate. The question is, does a will avoid probate? No. Assets controlled by a will do not avoid probate. A will by its nature directs the assets through the probate process for administration and ultimate distribution to the beneficiaries. There are a number of ways to avoid probate. First, you can give away all your money and assets, so you have nothing to pass along. Second, you can add a joint owner to your assets or add a payable or transfer on death designee to your accounts. Third, you can establish a life estate on your property. Finally, you can avoid probate with a trust. Adding a joint owner or adding a payable or transfer on death designee is a simple solution. However, they do not offer the same benefits as a trust. Adding a joint owner or adding a payable on death or transfer on death designee does not offer asset protection for beneficiaries, can potentially cause a loss of government benefits for a beneficiary with a disability or special needs, and does not help with potential future incapacity. With a life estate, you do not own entire interest in the property. The interest in the property is split into two pieces: the current interest and the interest the other owner, the remainderman, has after your passing. Additionally, if you wish to sell the property, you can only sell the portion you own, your life estate, and you would need permission from the remainderman to sell the entire interest. A properly set up and funded trust can solve these issues. A trust can give possible asset protection for beneficiaries. With a trust, you can retain control of assets. A trust has the ability to protect beneficiaries with disabilities or special needs. Finally, a trust can plan for incapacity. The only downside of a trust is the initial setup. To ensure your will or trust is set up properly, contact Heritage Law Office today.
In this video, we'll talk about what you need to know about the advantages and disadvantages of establishing a trust. If you're contemplating setting up a trust, this video is designed to help you make a more informed decision. Let's get started. What is a trust and why is it important? First, let's answer a common question: what exactly is a trust? A trust is a legal arrangement that allows a third party, called a trustee, to hold and manage assets on behalf of beneficiaries. Trusts are commonly used in estate planning, wealth management, and asset protection. They can help individuals achieve various financial and personal objectives, such as providing for loved ones, reducing taxes, or ensuring privacy. Now that you understand what a trust is, let's move on to explore the different types of trusts you can establish. There are many types of trusts, each serving a specific purpose. Some common types include revocable living trusts, irrevocable trusts, testamentary trusts, special needs trusts, charitable trusts. Each type of trust has its own set of advantages. Let's take a closer look. Trusts offer a multitude of benefits. First, they give you significant control and flexibility over how your assets will be managed and distributed. You can establish specific terms and conditions, aligning your trust seamlessly with your unique goals and needs. Another major advantage is probate avoidance. Probate is a legal procedure that validates a will and distributes assets. Trusts, however, bypass this process entirely, enabling a faster and more confidential asset transfer to your beneficiaries. Tax benefits are also on the table. Some trusts can substantially minimize estate, gift, and income taxes. For instance, an irrevocable trust can effectively reduce your taxable estate, offering potential tax savings for your beneficiaries. Lastly, trusts are excellent tools for asset protection. They can shield your assets from creditors, lawsuits, or even divorce proceedings. While trusts offer significant advantages, it's essential to also consider the disadvantages: complexity and cost. Even though trusts are highly beneficial, they come with some drawbacks. The most glaring ones are their complexity and associated costs. Establishing a trust requires experienced legal guidance, and there may be some administrative fees involved. Additionally, some trusts, particularly irrevocable ones, lack flexibility. Once established, they can't be easily changed or dissolved without the beneficiary's consent. Finally, trusts can sometimes fuel conflicts among family members or beneficiaries, especially if the trust is perceived as unfair or if the trustee is not acting responsibly. Understanding both sides of the coin can help you make a well-informed decision about whether a trust is right for you. A trust can offer numerous advantages, such as control over asset distribution, probate avoidance, potential tax benefits, and asset protection. However, there are some drawbacks to consider, like the complexity and cost of establishing and maintaining the trust, potential irrevocability, and the possibility of conflicts among beneficiaries. For more information on each type of trust, explore some of our other videos where we break these down individually. If you found this video helpful, remember to like and subscribe. Thank you for watching.
If you die without a will, the government decides who gets everything you own. Yeah, everything. Estate planning isn't just for the rich or the old. If you have a bank account, a car, a pet, or a kid, this is for you. Here are 3 things every adult needs: a will, a power of attorney, and a healthcare directive. And no, it doesn't take months. You can set this up in a short period of time. Without a plan, your loved ones could face court delays, legal battles, and stress right when they're grieving. Don't leave a mess. Start your estate plan today. Even a basic plan is better than nothing.
In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial. They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, Managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth as possible. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more informative content. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive, and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. Contact Heritage Law Office today for a free case evaluation. An estate plan is a collection of legal documents and strategies that outline how your assets and affairs will be handled in the event of your death or incapacity. Key components of an estate plan include wills, trusts, powers of attorney, and healthcare directives. There are several compelling reasons to have an estate plan. First, it ensures that your wishes are followed regarding the distribution of your assets and care of your dependents. Second, it protects your assets from unnecessary taxes, expenses, and legal fees. Third, it provides for your family by outlining your intentions clearly, reducing stress and uncertainty for your loved ones. Without an estate plan, your estate may face significant legal complications and delays. This can lead to increased costs and taxes, reducing the inheritance you leave behind. Additionally, the absence of clear instructions can result in family disputes and conflicts over your estate. Starting an estate plan involves several key steps. Begin by taking inventory of your assets, including property, investments, and personal belongings. Decide on your beneficiaries and how you want your assets distributed. Next, consult with an experienced attorney to draft the necessary legal documents, such as a will or trust. Regularly review and update your estate plan to reflect changes in your life, such as marriage, divorce, or the birth of a child. An estate plan isn't just about distributing your assets. It also includes making decisions about your healthcare and financial affairs if you become incapacitated. Powers of attorney and healthcare directives allow you to appoint someone you trust to make decisions on your behalf, ensuring your wishes are respected. Having an estate plan is crucial for ensuring your wishes are respected and your family is protected. Don't wait until it's too late. Contact an attorney to start your estate plan today. This proactive step can provide peace of mind and security for you and your loved ones. Thank you for watching. Make sure to like and subscribe for more. A revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate. Contact one of our attorneys to make sure your assets are properly protected. In this video, we will discuss everything you need to know about irrevocable spendthrift trusts and how they can protect your assets. An irrevocable spendthrift trust is a type of trust designed to provide strong asset protection and financial security for beneficiaries. Once established, the trust cannot be altered or revoked, ensuring the truster's intentions are preserved. This type of trust also includes spendthrift provisions, which prevent the beneficiary from transferring or mismanaging the trust assets. What are the benefits of an irrevocable spendthrift trust? Is its ability to shield assets from creditors. Since the beneficiary does not have direct access to the trust principal, creditors cannot claim these assets to satisfy debts. This provides significant protection, especially in cases where the beneficiary may face legal or financial challenges. Additionally, spendthrift provisions ensure that beneficiaries receive financial support without the risk of misusing the funds. This is particularly beneficial for those who may lack financial acumen or have a history of reckless spending. Moreover, placing assets in an irrevocable trust can potentially reduce the taxable estate of the truster, thereby lowering estate taxes. Creating an irrevocable spendthrift trust involves several key components. The trust document is the legal instrument that establishes the trust, outlining the terms and conditions. Selecting a competent trustee is crucial as they manage the trust assets and ensure distributions align with the trust terms. The beneficiaries are the individuals or entities designated to receive the benefits of the trust. The spendthrift clause restricts the beneficiary's ability to transfer or pledge their interest in the trust, protecting the assets from creditors and financial mismanagement. When establishing an irrevocable spendthrift trust, it is essential to comply with state and federal laws. Trust laws vary by state, so understanding specific regulations is important. Establishing this type of trust can also have significant tax implications. Consulting with a knowledgeable tax attorney or accountant is advisable to navigate these complexities. Additionally, the trustee has a fiduciary duty to act in the best interests of the beneficiaries, managing the trust assets prudently and transparently. Irrevocable spendthrift trusts can be tailored to various estate planning needs. They are particularly beneficial for young or vulnerable beneficiaries, providing controlled financial support. Families looking to preserve wealth across generations often use these trusts to ensure that assets remain available for future generations. They are also valuable in special needs planning, providing supplemental support without jeopardizing eligibility for government benefits. Business owners can protect their assets from creditors and ensure smooth business succession with these trusts. Let's look at some success stories. Jane, a successful entrepreneur, used an irrevocable spendthrift trust to ensure her teenage son Mark's financial security. The trust provided Mark with a steady income for education and living expenses, while the principal remained protected. Irrevocable spendthrift trusts are powerful tools for asset protection and financial security. They provide structured support for beneficiaries, protect assets from creditors, and reduce estate taxes. To ensure your trust meets your specific needs and objectives, seek professional advice. In this video, we will explain how a charitable trust works, the benefits it offers, and the steps to establish and manage one. Charitable trusts are legal entities created to manage assets for charitable purposes. The two main types are charitable remainder trusts, or CRDs, and charitable lead trusts, known as CLTs. Each type serves different purposes and offers distinct benefits. A charitable remainder trust allows you to provide income to yourself or other non-charitable beneficiaries for a specified period, after which the remaining assets are transferred to the designated charity. On the other hand, a charitable lead trust provides income to the charity for a specified period. After this period ends, the remaining assets are distributed to your non-charitable beneficiaries, such as family members. Establishing a charitable trust offers numerous benefits. First, the tax benefits are significant. Donors can receive income tax deductions for the value of the assets placed in the trust, reduce estate taxes, and avoid capital gains taxes on appreciated assets. Additionally, charitable trusts support important causes, enabling you to leave a lasting legacy. They also offer financial planning flexibility, providing a steady income stream and professional asset management. Setting up a charitable trust involves several steps. First, define your philanthropic and financial goals and choose the type of trust that best suits your situation. Next, select the charitable beneficiaries and work with an attorney to draft the trust document. Transfer the assets into the trust, appoint a trustee, and obtain a tax identification number for the trust. It's essential to seek professional legal and financial advice throughout this process to ensure compliance and maximize benefits. When establishing a charitable trust, consider the type of assets you will use. Cash and securities are straightforward, but real estate and business interests may require proper valuation and management. Accurate asset valuation is crucial for tax purposes and income distribution. Selecting the right trustee is also vital. The trustee manages the trust's assets, makes income distributions, and ensures compliance with the trust terms. Choose someone experienced and reliable, or consider institutional trustees for professional management. Creating a charitable trust requires ongoing management. Regularly review the trust's performance to ensure it meets its objectives. This includes evaluating investment returns, verifying income distributions, and confirming that charitable beneficiaries use the funds as intended. Adjust the trust terms as needed to reflect changes in your circumstances or goals. Ensure continuous compliance with IRS regulations and legal requirements by consulting with your attorney and tax advisor. Establishing and managing a charitable trust can be complex, but with the right guidance, it can provide significant benefits. By taking the time to understand your objectives and carefully planning the details, you can create a charitable trust that supports the causes you care about while providing financial benefits for you and your heirs.
Do you actually need a power of attorney? Or is it just something lawyers try to sell you? Here's the truth. If you become incapacitated tomorrow, who pays your bills? Who makes your medical decisions? Without a power of attorney, your family has to go to court. That process can take months and cost thousands. A power of attorney lets someone you trust step in immediately. No court, no delays. So ask yourself, do you have assets, a family, a business? Are you over 18 years old? Then yeah, you probably need one. Drop a comment if you've set yours up or tell me what's holding you back.
In this video, we will explore how trusts play a crucial role in business succession planning. If you're looking to ensure the smooth transfer of your business to the next generation, stay tuned. Business succession planning is essential for the longevity and stability of a business. Trusts are a powerful tool in this process, helping manage and transfer business assets effectively. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages assets for the benefit of another party, the beneficiary. Trusts can provide several advantages in business succession, such as maintaining control over assets, offering tax efficiency, protecting against creditors, and ensuring continuity and stability. There are various types of trusts used in business succession planning. Let's briefly discuss some of the most common ones. Revocable trusts allow the